a second for it to go anyway.
What is Amazon Chimes?
Wow, that's one I've never heard of.
Yeah.
I'm not seeing these for some reason. Hang on.
Hmm.
Okay, we're live, so I'll work on those, Dominic.
Okay.
Yeah, I'm not seeing those, but we're gonna boot this note taker here.
Yeah.
Not sure why that keeps showing up now. I don't see an Amazon Chimes here.
Well, no. That's I guess that's a.
I resell for Nextiva, and they chose Amazon Chimes as their web conferencing collaborating partner, and for various sundry reasons. But it's the first time I've heard of it, and I haven't had anybody else who had asked me to use it yet. But anyway, it's a new one, and I don't know all the different features, and well, maybe it's somewhat related to security relative to Zoom. But anyway, that's just sort of thought I'd throw that out there.
Gotcha. All right, Dominic, we're ready when you are.
Okay. Come on. Dave, give me co-host power.
Oh, yep. Sorry, I forgot to do that. I thought I did that before, but apparently I made the wrong person co-host.
Okay.
You have the power.
Fantastic.
And let me just change the screen sharing options.
Okay.
You should be able to go now. Sorry.
Awesome.
George, you can never leave again.
No kidding. Why? All right. Well, I'm just going to go ahead since my PowerPoint keeps collapsing on me today. So welcome to 1 Million Cups RTP. Thanks for being here this morning. We've got a really cool presentation that I'm excited about. But first, I want to just let everybody know who may be watching on Facebook or is here for the first time a little bit about 1 Million Cups. So 1 Million Cups is an entrepreneurial support and ecosystem building organization that is powered by the Kauffman Foundation. Kauffman Foundation being a $4 billion endowment for the promotion of economic development through entrepreneurship. There are about 160 plus chapters of 1 Million Cups nationwide. And the only thing you need to do to be here is show up, participate, and have a love of drinking coffee, as well as helping entrepreneurs further their business. So this is a industry agnostic, no pitch environment, giving a friendly environment for entrepreneurs and new business owners an opportunity to come in front of the group and ask the question, what can we do for them? So typically there's a presentation of about 6 minutes, followed by 20 minutes of question and answer. There's usually 1 to 2 presenters a week. This week we don't have a presenter who is presenting a business, but more of a concept that is very near and dear to everybody's hearts in the entrepreneurial community, particularly in RTP, where you have a lot of innovative entrepreneurs who are wanting to share their ideas, but do it in a safe way. We like to ask people to get involved. There are many ways that you can do that and get involved with the local chapter of 1 Million Cups. You can apply to present. That's very easy. If you have a business or an early stage startup company or an idea and you want to know how to get in front of people and make presentations, just go to www.1millioncups.com/RTP. And there's an apply to present button there. It's a very easy process. and then we'll walk you through the steps to actually become a presenter and develop your presentation. If you know somebody who is an entrepreneur that you think could benefit from this forum, please invite them to come, see what we're all about, and then maybe they would like to present. We always ask for more people to become organizers. This is an all volunteer organization. We do spend a lot of our time making sure that these meetings are here on a weekly basis and get interesting and innovative presenters to come and share their thoughts and ideas with you. And then the last but not least, show up, engage with the presenters, ask questions, give feedback. And one of the things that we challenge people to do is bring somebody else who'd be interested in this. You know, we've got a lot of people that come here week after week. We see the same faces. Bring somebody. I know you know somebody in the topics that we discuss here. So I would like to thank the organizers that we have here on the call today. I see George Stewart and David Bates. They're two of our coaches. Terry Conlon is not here today. We have Krissa Johnson Sotomayor. She is our past lead organizer and head cheerleader and ambassador for the group. Let's see, Rosalinda Cruz, she is not here today, and neither is Dan. Let's see, who else do we got? Tracy Ames, not here, but she is the intake coordinator. William Clote, also not here today, but that's okay. And if I'm forgetting anybody else, please forgive me. I'm usually doing this off of a PowerPoint, but which I don't have this morning. I'd like to thank our sponsors. We've got Muddy Dog Roasting Company. Of course, Soto IP, who is here today, is one of our sponsors. We've got Wise Insights, which is Mr. Bates's company. We've got Imperative Product Operations, GTI, American Underground. Let's see, who else do we have? NC Idea, and if I'm forgetting anybody else today, please forgive me again. So we'll get right to the presentation. Today we're doing a community forum. We've asked, and he's agreed, John Sotomayor of Soto IP to come and talk a little bit about protecting your intellectual property when sharing your ideas for your business, how to keep yourself safe while still being able to engage with people and not, for lack of a better term, not be too paranoid, but also not get your idea taken from you. So this is something I'm sure he discusses all the time. This is something that comes up with our coaches when they're trying to coach people with presentations and they ask, well, I don't want to share too much. I can't talk about it because I don't want somebody to take my idea, which is, it's a natural concern. So John, the way we're going to do this, John's going to talk for about somewhere between 5 and 10 minutes. We're going to give him a lot of flexibility here, and then we'll just open to question and answer. Question and answer format is just like we've been doing, except you're going to, today, David Bates is running that. So send a private message to David Bates. If you have a question, he will put you in the queue. And then when it's your turn to ask a question, it will call on you, unmute your microphone, and then ask your question. So, John, thanks for being here.
Thank you, Dominic. Thank you,
sir.
Dave. I really appreciate the opportunity to talk about this. This is a very, very important, as you said, a very, very important topic, and one that I hear, like I said, about from 60% or so of our inventors that we work with. They're all curious about this particular topic. I did want to take 30 seconds to give a little bit about my background. Started out as an electrical and computer engineer, did that for about 18 years, went to work for the patent office in 2001, became a senior examiner before I decided that it was time to go to law school, moved to North Carolina, where I worked as in-house counsel while I was going to law school. And then once I graduated from law school, joined a different company as in-house patent counsel We sold that business. It was called Digital Smiths. Sold that business for $140 million. And then after that, we, in combination with my spouse, Chrissa, we started a business called Soto IP because we realized there's a lot of entrepreneurs out there who either don't know or don't understand the information about the patent process. And one of the biggest topics before you ever start talking about whether you should file for IP protection, one of the biggest topics is, what can I talk about with regard to my idea? How can I pull that forward without, as Dominic said, fearing somebody to take it and run with it behind my back, so to speak? Well, the first thing that you need to realize about ideas is that ideas are a dime a dozen. They really are. And I know that may sound weird to have somebody like me say that, but what really patents protect are the reduction to practice of those ideas. And that really gets to the core of how you can move forward with talking about what you're doing without losing out on your ability to protect your intellectual property. Because practically speaking, patents protect ideation and creation, but only as you reduce it to a practice that can bring some result into the real world. And these actually are legal terms that I'm talking about. So how do you move forward with talking about what you're doing without giving away too much of the store? Well, the key to that lies in that term, what. You can talk about what you're doing all day long, because as I've seen in my practice over the last 20 years, you can get from point A to point B any of a dozen different ways, and all dozen of those different ways might be separately patentable, because what's important about protecting intellectual property is how you went forward from your idea to the actual practical expression of a product in the marketplace. Okay, so how does that translate into what you can talk about? Well, when you're talking to a group of people and you say, I've figured out a way to predict where lightning's going to strike with 99% accuracy, stop there. There you're at the 30,000 foot level. They understand exactly what you're trying to do. It's a new idea that you've expressed, but you haven't said anything about how you actually reduced that to practice. That's the important part. So keep in mind, you want to talk about what you're doing, what the final result is. Don't talk about any of the steps that get you from the initial problem to the final solution. So when you dig down into those steps of how you did it, which you're going to have to do when you go and talk to a VC, the way to minimize your risk when talking to VCs, because I'll tell you, based upon practical considerations, VCs will not sign a non-disclosure agreement. And they have good reasons for doing that. But the the American Invents Act, which defines patent practice in law, basically states that if you publicly disclose your innovation, then you have 12 months to file for IP protection. But public disclosure has a very specific definition. Under the law, public disclosure means it's something that you have marketed in terms of how you're doing what you're doing. It's something in which you have gone out to sell it, including all of the details of how you're going to, again, provide that solution. If you've talked about it in a public forum, such as this, or if you've published it in a publicly available document. If you've done any of those things, then you start that 1-year time clock. Unfortunately, if you wish to file for international patent protection, once you've publicly disclosed something, you destroy your right to do so in Europe. So the thing you want to do is, before you do any public disclosure, you want to try and file for intellectual property protection if you're at that stage. But if you're going to go seek investment in order to avoid the dangers of premature public disclosure, just simply get behind closed doors when you're talking to an investor and say, this is confidential information. And then you can talk about what you want to talk about. And that's not considered public disclosure. So you've minimized the risk of anything leaving that room prematurely. You've talked about the details that the investor is going to be interested in, and you've enjoined him basically by saying this is confidential information. And I've never talked with a VC in all of the time that I've been doing this practice who didn't honor that commitment. So you can see that if you're at the 30,000 foot level, talk about what problem you're solving, what your solution does in the marketplace, but leave out all of the details about how it does it, then that's not public disclosure, and it minimizes your risk that somebody's going to come along and take your idea, because they're going to have to go back and recreate exactly what you did in terms of the steps of getting from the problem to the solution. And that's really where your intellectual property lies. That's the innovation and creation that you did, because you have to create something in a product that solves that problem in the marketplace that's not otherwise available. So with that, I know I've given you all a lot to think about, but what I'd like to do is just kind of open it to questions and see what's on y'all's mind.
All right, David, do we have anybody in line for Q&A yet?
I do not have anyone in line for Q.
Well, let me just remind everybody of the process. So David is facilitating the question and answers. So if you have, if you have a question, please PM David that you would like to be in queue. And when it is your turn, he will call on you to ask your question and unmute your cam or your microphone and go ahead and ask it. So
wow, I can't believe I did so good a job that nobody has.
Yeah.
Well, so Bob is willing to get us kicked off here. So Bob, why don't you get us start, and then if nobody comes in behind you, then you can ask your next one. Fair enough.
Oh, okay. All right. Well, all right. Well, I like the fact we couldn't get anybody else this morning, so we got John. This is great.
That is
Thanks.
actually
That's really
not
flattering.
the case. Thanks for pointing that out.
So actually one specific thing to your commentary, and then I've got one scenario that I want to throw out to the group that's kind of interesting.
Sure.
You mentioned about domestic patents versus international.
Mm-hmm.
You touched on that.
Yes.
Given the way you described it, would it be a strategy to file an international patent first before you start marketing, so you can therefore kind of hedge that protection?
Well, there's a way to focus on that, and you may certainly file an international patent first. However, there are two different avenues for filing for international protection that both go off of U.S. patent filings. Those two are the Paris Convention and the PCT, the Patent Cooperation Treaty. In each case, what you do is you file a U.S. patent application first. And then for the Paris Convention, within 12 months, you would then go out to whatever other country you wish to file in, utilize the U.S. application as a priority document. Because if you publicly disclose something prior to a patent filing, then that destroys your rights. But if you publicly disclose something after you have done a filing in any country, even the US, then that's not considered public disclosure because you've already put your protective stance in place. So you can file under the Paris Convention within 12 months, or you can go through the Patent Cooperation Treaty and file, again, based upon the US application as a priority document, file to reserve your right to file in other countries for up to 31 months from the date of the US priority application. And the PCT occurs in two stages. The first stage, again, is reserving your right for that 31-month period. That's sort of like an international provisional, if you know what a provisional application is. So you can utilize the US application, as I said, as a priority document. So it's not been publicly disclosed prior to your filing the US application, but then you can go and utilize that US application and seek entry into other countries under the Patent Cooperation Treaty off of the US application. And the Patent Cooperation Treaty is signed by 153 countries across the world. So it's a very powerful vehicle. In fact, we actually do this quite a bit for our clients. The cool thing about it is when you file the US application, you have 12 months from the date of priority of the US application to either file under the Paris Convention or reserve your right by filing to reserve your rights under the PCT. If you do miss that 12-month window, however, you will not be afforded the priority to the U.S. application. And unfortunately, then what happens in that circumstance is the U.S. application is used as prior art against any foreign filing unless you've filed for improvement. So it gets a little tricky if you miss some of these dates, which is why it's important to talk about whatever patent practitioner you're working with. It's important to talk about these entry dates, either under the Paris Convention or through the Patent Cooperation Treaty. And the difference between the two is under the Paris Convention, you're actually filing in other countries a patent application. Under the Patent Cooperation Treaty, you're reserving the right to then move forward to file a patent application in these other countries. But either of these vehicles exist, again, utilizing U.S. application as a priority document.
Okay, I'm gonna pop in here real quick in between here, Bob, just because we have actually a bunch of folks who have questions.
Great.
So your scenario, if it's a quick one, we can kind of take it now, or we can come back around after some other folks get a chance to ask. I don't know if that's tied to the question that you were asking.
It kind of is, and I think it might actually benefit. This is a current scenario. So I'm involved with a company that actually invented an anchor product for concrete, and obviously concrete is pretty much global general building material, right? And it helps avoid post install drilling, which everybody has a problem with. So they filed the U.S. patent, and they got it approved in 18 months, and it came back with no conflicts whatsoever in terms of, but they're actually also looking at a global marketplace. So I was wondering where that kind of maybe applies to this whole, in terms of a strategy around protecting it in a broader sense. Now, I don't know if that helps, David, or, I thought it could be helpful.
No, this is a good scenario because it raises an issue that's important to understand. Bob, has the patent been granted in the U.S.?
Yes, it has.
Okay. The problem with that is that all of the filing, both nationally and internationally, if you wish to use priority of a U.S. application, it has to be in prosecution in order for you to use it as a priority document. The day that the patent publishes, it's no longer in prosecution. You can no longer use it as a priority document. So unfortunately, unless they file a new application with improvements to the patent that was granted, they've lost the right to tie international filings to that granted U.S. patent.
Okay. So that might be an opportunity for somebody to talk about like what strategy that would be most effective to gain them.
Yeah, Bob, we can talk offline about it if you like.
Sure. Yeah, no,
Yeah, thanks, Bob. That was
sure.
Great. Okay, so I got a couple here that are queued up. Mark Dixon will go first, and then Dominic has a question from Facebook, and then after that, Brett. So I'll refresh the order in a minute, but just want you guys to be acknowledged that you're in the queue. So Mark, if you want to come off of mute, I don't know if your phone's going to let you. Oh, there you go.
Mark.
I'll try. Sorry about being on mobile. I'm
all good.
Having some technical difficulties. So my question about intellectual property is, I filed some disclosures for a company I used to work for, but they did not file this intellectual property, and it's been left without action for a couple of years. My question is, can I either publicly disclose that intellectual property, give myself a year and file provisional, or am I not allowed to do that because since I disclosed it within their company boundaries, it's now their property?
Well, Mark, believe it or not, you got three issues there. The first one is that under the American Invents Act, if you don't file for patent protection within a 12-month span of time from public disclosure, then your right goes away. However, if the company has kept it confidential, and has not publicly disclosed it, then you don't really have to worry about that. However, the second issue is that when you filed this for the company, I can guarantee you that the company has some sort of clause, an IP clause in your employment contract that states that it belongs to them. So in order for you to move forward, what you need to do is seek a release from them. Say, you know, hey guys, I noticed you didn't move forward with these. I would like to move forward with them. May I do so? And if they provide you with a release, then you're free to move forward however you wish. But if they don't provide the release, then you're just stuck. The third issue is that if it has been publicly disclosed, then again, you lose that right. But if it hasn't been publicly disclosed and you get a release, then what you'll have to do is file for patent protection before you personally publicly disclose it. Otherwise, you may lose that right because of time issues. So if you can get through those three conditions, I think that you can move forward with that.
Okay, just to one follow-up to that, or I guess to clarify. So let's say I put this idea on my LinkedIn account and just left it out there for 12 months. It's been publicly disclosed, and then no one can claim that intellectual property, right?
That's correct.
Which means I can use it. I can use it, I
That's
just
correct.
don't have protection. Okay,
That's correct. And
All right, thanks a lot.
nobody else can file for a patent on it either.
okay. But if I do want to file protection, I have to file it before
And
the
disclose
12
it.
months. Okay,
Yes.
got it. All right, well, thanks a lot for the clarification. I appreciate it.
You're welcome.
Okay, so Brett has a question, an interesting one, given his work in academic setting. So Brett, if you want to come off mute and turn your camera on, that'd be great.
Yeah, I thought Dominique was next. Thank you.
Oh,
Yeah,
I'm sorry. Yep, Dominic, we'll flip it. Go ahead.
okay. Thanks for being on. So I have, good to see you again, John. I
Hi,
teach at
Brett.
North Carolina Central, but I also work with the LEAD program. So
I got my law degree from NC Central. Just want to let you know
that makes you really smart.
that. Thanks.
Yeah. But I'm even teaching an entrepreneurship course right now, and I wanted to understand better, it's a two-part question. Where can I get some IP for dummies or for students? I'm sorry, for students. But when they're doing their presentations, which they're doing their last one today, or they're in the LEAD program, how are we, is that public disclosure then, or is that treated more like the investor disclosure? How does that work? Yeah.
Brett, tell me a little bit about exactly how they're doing the presentations. Is it open? Is it an open forum?
Right. Well, the ones right now, they're done in a Zoom room just like this.
Okay, yeah.
So,
Okay, yeah.
so Ricardo's been a part of it. Cindy's been a part of it. So.
Cool. Yes, that would be considered public disclosure, which means that you start your 12-month time clock. With regard to resources, though, we have worked very, very hard to attempt to provide all of the information that we believe entrepreneurs. I would like to direct you to our website, sotoip.com.
Okay.
And there are a number of resources there. We provide this information freely. We want you to understand exactly what the entire process is all about. And because I've been an engineer and an examiner and in-house counsel and run my own practice, our view is a 360-degree view of the information needed. You know, what does it mean to file? What does it mean to prosecute? How do you deal with examiners? What does international protection look like? What are the priority dates? All of that information is available on our website under the resources that we have there. So I would say that that is probably a very, very good place for you to start. Gathering the information to help your students really get through this process, because it is a 200-year body of law. It has changed 3 times in the last 30 years,
Wow.
but all of the information in there is current.
Okay. Thank you.
You bet.
All right, so Dominic, I apologize for hopping over you on the question from Facebook. So
That's okay. So we have a question from Airday. Apologize if I messed up the pronunciation there. So he asks, how much does it cost to get a patent registered? Going back to the question about international versus US, I hear international can get pretty expensive. Is it worth it to start with international right away or start with US? I think you addressed that before, but can you address the expense issue of getting patents registered?
I can give you some brackets
Sure.
because it all depends on several factors. First of all, what is your idea like? Is it highly complex? Is it a simple device? Is it a new toy? It depends upon what you're doing in order for you to talk with a patent practitioner as to the level of effort that it would be required to both prepare and file an application, and their considerations of prosecution afterwards. Because when you prosecute a patent application, you're going back and forth with a patent examiner about the patentability of claims. And each time that you receive a communication from the patent office, it's called an office action. Each time you receive an office action, you have to respond to that. And those office actions cost anywhere from $2,000 to $5,000 to reply to, because it's a legal response. It's in accordance with the statutes. And so it typically takes a practitioner a full day in order to respond to these. The average number of responses that you have to file before you get to patentability, and this is the USPTO's statistic, not mine, but the average number that you have to respond to is 3. It can be more than that, it can be less than that. In fact, our average is closer to 2 because we're a lot more careful about how we actually move forward with claim language. Again, being a former examiner, I understand the parameters pretty well. But that being said, it can be pretty costly, both in terms of the initial filing and the prosecution. And remember, these are 2 separate steps, each of which has a cost associated with it. Now, if you're going to start with filing a US patent application, and I won't have real good numbers for you on international, but the US patent application is going to cost anywhere from $7,500 to $15,000 for the initial draft and filing. And again, it depends upon the complexity and exactly who you go with. I mean, if you're doing a pharmaceutical patent, that initial filing can go as high as $30,000. I've seen some go that high. Since we don't do pharmaceuticals, that number is a little softer than these others that I have, but we're sort of right in the middle of the road in terms of, the initial preparation and filing cost. Now, that being said, you also have to budget for those office action responses that come about in prosecution. If you're going to budget for those, remember that it's going to be $2,000 to $5,000 for each response. So we use a number of 3,000. Say you need to budget 3,000 for each office action response, and you should budget for 3 of them at a minimum. That way, if it comes in and you only need 2, then you save some money out of your budget. But if you need 4 or 5, and believe it or not, the worst one I've ever seen was I was doing some patent applications for Microsoft, and we went to 8 office action responses before we got to patentability on one particular software project that they were doing. But the good thing about prosecution is that you can budget that over time, because each cycle for an office action response is about 6 months. So you can budget for that, those 3 office actions over a 12 to 18 month span of time. But totally taken together, you have the initial drafting and filing, again, between $7,500 and $15,000, depending upon complexity. And then the prosecution budget, which would run you anywhere from $9,000 to $12,000, again, spread out over 12 to 18 months. But taken together, that's what you need to think about as a practical budget for a patent application, from drafting all the way through prosecution to allowance.
John, there's a couple of questions that actually would would dovetail nicely with that and follow up, and that has to do with the investment in the patent relative to the ability to defend the patent after it's issued. Can you talk a little bit about how to make that kind of trade-off decision?
Sure. Part of the issue with understanding whether you should file a patent or not is not just about whether you can defend it, but if you want to monetize it, okay? Because what happens is when you actually get a patent, then it is a piece of property, and you can monetize it through licensure, through sale, through reciprocal arrangements for other patents that you want to use. So that's part of the consideration. It is also true that if you're not prepared to defend your patent, then you really should spend the money, on marketing dollars and try and run as fast as you can in the marketplace. Part of the problem with that strategy is that you can't stop anybody from making, using, selling, or importing your patent and invention because you don't have a patent. So you're taking a risk. And again, if we look at the outside of the brackets of costs that I gave you, it's going to run you between $21,000 and $30,000, all told, to get a patent. The average patent is worth about $85,000. There are some that are worth $1 billion. There are some that aren't worth very much at all. But the average is about $85,000 to $100,000. So you're investing $20,000 to $30,000 to get a property that's worth $85,000, and from which you can, if it's a well accepted product, you can derive considerably more in terms of licensure. Now, the way to think about protecting it is there's a 3-step process. And we've seen this several times with clients who've had to defend patents that we've gotten for them. The first step is that if you notice, and it's up to, according to law, it is up to the patent owner to discover if their patent is being infringed upon. If it is being infringed upon, then the very first thing that you do is you contact an attorney, have them draft a letter offering to license your patent to the infringer. And the thing about that is it's commercially reasonable. You're giving them a chance to make it right, and you're gaining some income off of your property. So from the legal standpoint, that's the first step you should be taking because that's commercially reasonable. If they decline your kind offer of a license for your patent, then the next step is a cease and desist action. And that's writing that initial letter is going to run you a couple thousand, maybe $2,000 to $5,000. A cease and desist letter is going to be a little bit more expensive because now you got to get a prosecution attorney involved, somebody who does patent litigation, and they will draft a letter basically saying, look, we gave you a chance. We want you to stop doing what you're doing. We request that you cease and desist. Otherwise, we will file a lawsuit. 90 to 95% of the time, one of those first 2 steps is effective. The other 5% of the time, let's say that you patented the transistor. The very first lawsuit in that one was $5.4 million back in the early 60s to defend that. But Texas Instruments made billions of dollars off of transistors by defending that patent. So it was really worth it to do that. But if you have to go to litigation, understand that the average patent lawsuit costs between $5 and $7 million to defend. So if your patent is earning you a great deal of money, which many do, it's worth doing that. But that's the third step. For somebody who's an entrepreneur, 9 times out of 10, the individual who is infringing upon your patent is going to be an entrepreneur also. And so they're not going to want to go to court any more than you do. So if you offer them a commercially reasonable license, out of the 4 or 5 times we've seen this happen, it's been taken up every time. There has been one instance where we had a client who had to defend against Chinese infringers. And what happened was she was able to get their offending products taken down off of eBay and Craigslist and Amazon, and also stop the imports at the border so that they couldn't import them into the United States. She's also gotten millions of dollars worth of judgments off of these Chinese companies, which she says I'll never collect, but she's now got the market to herself, which she should have in the United States. So without patent protection, anybody can come along and copy what you did. With patent protection, you have ways to monetize it, you have ways to stop others. And so on balance, if it's something that has a good market and you can see it going nationwide, it's worth the money to invest in a patent.
Yeah, so this is a great sort of end to end of the process and the pieces, and I think it emphasizes the need for competent counsel when you have an idea and you're thinking about protecting it. Alfred,
or at least somebody who's done it before.
yeah. Well, I mean, your point though earlier about sort of the experience of the person doing the application can make a difference in real financial terms, because if you don't know how to structure the claims, you can end up with a lot more office actions, which then just add up the cost. So that's kind of the nuance there that I wanted to make sure that we called out.
I agree with that.
A couple more questions. We're getting low on time, but Alfred, I wanted to come to you, and I think we've kind of covered a lot of the pieces of the process side of the question, but maybe you could ask about your two-part test question. If you want to come off mute and turn your camera on.
Hello, John. I'm Alfred. I'm an intern at NC Idea. I have my own startup, and I'm a senior at UNC Chapel Hill. I have a question related to a software patent. So I wanted to know what is required for a software patent, and can you give an example of a software that would pass the two-part test?
Oh, absolutely. We do this all the time, Alfred. Actually, one of our specialties is software and software hardware systems. We've had 20 or 21 software patents granted this year. So I think we have a pretty good handle on it. The two-part test was set forth in two different cases that were decided by the Court of Appeals for the Federal Circuit and the Supreme Court. The first one, Bilski, was decided by the CAFC, which set forth this two-part test. And then it was affirmed in Alice versus CLS Bank by the Supreme Court. There have been additional court cases after that, but basically what the two-part test says is in order to be patentable, a software process must achieve one of two things. Either A, it must improve the operation of a particular device or apparatus, or B, it must change something in the real world to a different state or thing. And basically what that means, it's got to provide a result to a human being upon which a human being may make a decision or take an action. And this is seen most clearly in a patent that was granted. This one was one that was one of the Microsoft applications that we did. They had created a new way of organizing the icons on a screen, not in a square, but in a helical spiral, sort of like DNA. And the way that you process through that is that it provides something on the screen upon which the user could touch in order for it to cause a different action to occur. So that provided a result in the real world upon which a user could take an action. So once you draft claims, you can talk about the process all that you want, but at the end of the process, you have to provide some sort of step that shows how it's used in the real world. And once you do that, then you get past all of the 101 issue, the statute that's utilized to say whether a patent claim is eligible or not is 35 USC 101. And so once you provide this result in the real world, you get past all of the issues surrounding 35 USC 101, you satisfied Bilski, you satisfied Alice, and your claims can move forward through prosecution. So that's the simplest way that I can tell you about that.
And that's the simple way.
yeah, that's the simple.
Sounds easy.
Yeah, I like that, Dave. That's the simple way.
That makes sense. Thank you. That explains it pretty well.
Oh, I'm
Fantastic.
glad. I'm glad. If you have
Dominic
any other
has-
questions, Alfred, let me know.
Yeah, sorry. Dominic has a question from Facebook, and that'll probably be our last question before we transfer into community announcements. So Dominic, you want to go ahead and?
Yeah, this one's from Peter Henderson on the Facebook feed. The question is, for younger students without the $20,000 plus to file a patent, are there any resources to help guide them with their ideas and innovations?
We, as I said earlier, we've worked very, very hard to provide a soup to nuts informational website to help people understand exactly how to move forward, what they need to be thinking about, and how to perform this process. It's not easy, you know, and the problem is that anytime that you get involved in drafting claims, it can be an extremely difficult and frustrating process for individuals who are not familiar with how to structure claims such that they both encompass the idea of the invention and yet meet all of the statutory requirements. However, that being said, I mean, you can, we provide information on sotoip.com on how to move forward with a provisional patent application. And then once you have filed a provisional, now the formalities for a provisional patent application are minimal. All they have to do is make sure that you have expressed your idea clearly in a way that it can be used as support for a non-provisional application later. So I would encourage students to file a provisional patent application describing their idea as fully as they can, not only what exists today, but also what they're planning on, how they're planning on improving it in the next 12 months, and then provide any diagrams that they wish to help describe it. You can file it that way, and you can file a provisional patent application on your own. The Patent Office is open to that. But when it comes time to convert it from a provisional to a non-provisional, it really, really is worth the time to get in touch with a patent attorney such as myself. Say, I have a provisional application. I would like you to assist me in meeting the formal requirements and drafting a set of claims. That is the least expensive way that you can convert from a provisional to a non-provisional. Now, I will tell you, if you go to a large law firm, they're not going to be interested in that. But if you go to smaller practitioners or small boutique firms, such as my firm, we can assist on an hourly basis. The hourly rates can run from $300 to $500 per hour, but you can get a quote on the number of hours that it would take to do that. That's the one place where you cannot scrimp on the cost. Otherwise, you shouldn't bother doing it. Because if you really can't afford, 4 or 5 hours of an attorney's time to get the claims right, you're not going to get the patent anyway. So go to the website and it'll give you lots of information.
John, what advice would you give to a person in that situation regarding your earlier comments about public disclosure and in terms of like what that provisional patent actually protects?
Sure. Again, the thing to think about is that a patent application, in order to make it through the prosecution, must describe in sufficient detail how you did your innovation in such a way that a person with the same level of skill as you have can recreate what you did just by reading your text and looking at your diagrams. So that's the level of disclosure that you have to have in a provisional patent application in order for it to provide support later on for a non-provisional and support claims. So you want to get to that level of disclosure. That's pretty straightforward. I mean, most people can do this. The biggest problem that we see is people not wanting to give up their secrets. Well, I don't want to tell them how I did it. Well, if you can't tell me how you did it, then you can't possibly draft a set of claims that would be patently distinct. You have to, the whole thing about intellectual property protection under patents is that the government gives you a monopoly in exchange for a complete description of how you did what you did. So you can minimize your cost by drafting a provisional application yourself, but that provisional application has to go through all of the steps on how you did what you did, such that somebody else can recreate it later. Does that answer your question? Cool.
Yes. Hey, John, we closing the Q&A period. Normally,
This has been a lot of fun.
Yeah,
Thank you.
Well, thank you for being here. We really appreciate your time. One thing that a lot of our presenters will do is stay after to do a general networking. I'm sure you've got to get going.
Unfortunately, I have a meeting in 10 minutes.
Of course. So how can people reach out to you to ask further questions? What would be the easiest way to do that?
Sure. There's two ways to contact me. The first is to, again, go out to our website. We just revamped it, so it went live last week.
Okay.
Just tap on the Contact Us tab, and it will provide you with a screen for asking questions and getting in touch with us. For the individuals on this call today, I'll give you my personal email address, such that you have questions. I'd be happy to do follow-up with you. You can contact me at John, John, at sotoip.com, and that will go directly to me.
Excellent.
Okay.
Thank you, John. Appreciate
All
that.
right.
So now we're going to go ahead.
I'm going to drop off for now, Dominic, so I can get prepared for my other
Of course.
meeting. But thank you all very much for having me. I really appreciate it. And just remember, sotoip.com is a good resource for information to assist.
Excellent. Thank you.
Thank you all.
All right. So we're going to go to community announcements now. Same format as question and answer. If you have something that you'd like to share with the community, whether that be an event that you have, a presentation that you're doing, something about your business that's coming up, we would love for you to just ping Dave, get in the queue, and make your announcement. And I bet you Brett has something. I think Helen might have something that's coming up next week with her company. I know that I am hosting next Thursday evening a Rockstar Connect event in the virtual format from 7 to 9 in the evening. You guys know how to get in touch with me. As you probably, most of you got an email from me at least once or twice this week. If you want the details on that, just go ahead and email me and I'll follow up with you. Anybody else have an announcement they would like to make?
I don't have anybody in the queue yet. I see Brett shaking his head no. Helen,
No.
did you have anything you wanted to add? Or
Helen, unmute.
you're unmuted, but we still can't hear you. You have mute on your headset?
Okay. Well, I know. So Helen is with White Rabbit Intel, and we've had Rob present here before, and they are doing a webinar this coming Tuesday. I think it's starting at noon with Sales Intel IO, and they're going to be discussing psychographic intel in sales and networking, which seems like a very interesting concept. It's a new way of looking at predictive and behavioral intelligence. I'm not sure really what it means, so I've signed up for the webinar to find out more about that because it sounds interesting, but I don't know anything about it. So I'm going to attend. Any other announcements?
Just
That webinar?
What was that?
When is that webinar?
That is, I believe, Tuesday at noon. Is that correct, Helen? Do you, if you can put the details in the chat for everybody, that would be great. Looks like Frank Jones may have something. Welcome, Frank. We haven't seen you in a while. Good to see you, my friend.
Yeah, I finally was able to hop onto one of these calls now that everything's virtual and didn't have meetings overlapping with the calendar. So that's awesome to be able to be back with the Million Cups events. I just had a quick announcement with the WordPress help desk. Since everything has moved online and virtual these days, that event has also moved online and virtual, and I will drop the link over in the chat if anybody has WordPress questions and wants to sign up for a WordPress help desk event.
Now, are you still doing the SEO forum as well?
The SEO meetup has unfortunately not been able to transition as easily. So
Okay.
I've been trying to figure out a good format for that. That one's a bit more complicated.
Gotcha. Fair enough. All right. I'll at least see the information there. Okay. Thanks for putting that link in the chat. And if we don't have any other announcements today, we're going to go ahead and wrap up. Thank you all for being here. Really appreciate it. And we'll see you all next week when we go back to, we have a great presenter next week. So looking forward to seeing you all there.
Yep. And
Anything from you, David?
if you want to review anything from today's presentation, you can go to the 1 Million Cups page on Facebook, and you should be able to review it after we finalize the meeting here.
Excellent. Well, thank you all again for coming. We'll see you next week, 9 o'clock on Wednesdays. It's coffee time with 1 Million Cups.